Great.
I'll get us live and then we will get going. All right. Okay, I think we're good. Go. Joe, if you want to go ahead.
Yep, sounds good. Good morning, everybody. My name is Joe Cap, and I am the co-chair of National Entrepreneurship Week. National Entrepreneurship Week is a congressionally chartered annual event which supports and uplifts America's new businesses and entrepreneurs. Originally founded in 2006, National Entrepreneurship Week takes place every year during the third week of February. In 2016, Amber and I relaunched National Entrepreneurship Week, and now all across the United States, from Maui to Miami to Maine and everywhere in between, America's entrepreneurial ecosystem is vibrant and thriving. We want to go ahead and welcome our friends over from the United States Patent Office. But before we do that, Amber, you want to go ahead and share with us some of the logistics for today's session?
Yes, absolutely. So if you're watching this on the Resource Compass or Facebook Live, please go ahead and use the chat function if you're here with us live in Zoom to introduce yourself. And if you have any questions, use the Q&A function. That just allows us to kind of make sure that we're keeping everything straight for our team and for the speakers. But with that, that's some quick housekeeping, and we appreciate and welcome the United States Patent and Trademark Office today. So I'm going to throw it over to Elizabeth to kick things off.
Well, good morning, and thank you to Amber and Joe. Speaking for myself and my colleague Jason, we are thrilled to be back again with National Entrepreneurship Week. We love this opportunity to engage with America's small businesses, independent inventors, entrepreneurs looking to make a difference, and having this opportunity to talk with you about a very critical piece of building and growing a business, and that's the use of intellectual property to protect your creativity and to help bring your business to that next level. We do have a slide set that we will be sharing and using for our conversation, but we do want to open the floor and have a lot of today's time together. And I know it'll be brief, but have a lot of our time together to be a dialogue and conversation. Um, Again, my name is Elizabeth Doherty. I am a 30-plus year veteran of the U.S. Patent and Trademark Office. My colleague Jason is with me here today, and I'll allow Jason to introduce himself, and then we're going to jump right into it. Again, thank you to Amber and Joe. Thank you to keeping the power of entrepreneurship alive. We're happy to be here with you today. Jason?
Sure. Thank you, Liz. Hey, everybody. I'm Jason Lott. I'm the managing attorney for Trademark's customer outreach at the United States Patent and Trademark Office. I don't have as many years as Elizabeth Doherty does, but I'm a 20-plus year veteran of the USPTO. And it is my job to teach people about trademarks, what they are, why they're important, and how the federal registration of your trademark can help you build your business. And a lot of the work that we do on the trademark side of the house is trying to get information in the hands of folks just like you. We want small business owners and entrepreneurs, no matter where you are in the United States, to know this stuff so you can use it to help yourself. Sometimes it creates a new business. Sometimes it creates generational wealth. Sometimes it creates something that you can pass down to your kids and your grandkids and your great grandkids. So we're happy to be here today. And Liz, if you want, I can go ahead and share the slide deck. We can get some foundational knowledge out there.
That sounds great, Jason. So as Jason is bringing up those slides, what are we going to cover today? Well, we're going to talk a little bit about the U.S. Patent and Trademark Office, perhaps one of the best kept secrets of the federal government. We're going to talk about the 4 basic types of intellectual property. Touch on, if we have the time and opportunity, touch on some of the valuable resources that we can provide to you, entrepreneurs, from the U.S. Patent and Trademark Office. But again, we want this to be your time, and we want it to be an opportunity for you to engage with us. Next slide, please. For those of you who may or may not know this, the US intellectual property system is as old as the country itself. In fact, intellectual property is written into the very US Constitution. Our founding fathers recognized that in order for us to be a strong and industrialized nation, we needed to protect the rights of authors and inventors for a limited period of time. Trademarks are also written into the Constitution in the Commerce Clause. So just letting you know, this isn't something that's come out overnight. This is something, again, that has been in existence since the very inception of our country. Next slide, please. Just to help you position where the U.S. Patent and Trademark Office is, we are a part of the larger U.S. Department of Commerce, and we often collaborate with our fellow commerce employees and fellow bureaus across the Department of Commerce, all bringing value to U.S. citizens, to companies, individuals. But as you can see, we have the Undersecretary for Intellectual Property and our Director, and we serve as the U.S. Intellectual Property Office. We are America's innovation agency, in fact. And just to give you another brief snapshot, just to help you position and appreciate who we are as an agency. Next slide, please. Well, again, I said we're one of America's best kept secrets. We are an agency of over 13,000 employees doing the fantastic work of issuing U.S. patents and federally registering U.S. trademarks. We have over 8,500 trained engineers and scientists that work as U.S. patent examiners, nearly 800 trademark examining attorneys. And this is what I find really exciting, Jason, is that we receive every year over 650,000 patent applications. And as you can see, trademarks are going through the roof, over 730,000 trademark applications. It's a lot of inventiveness, it's a lot of creativity, and it's a lot of intellectual property being created. Next slide, please. So as an agency, we are headquartered in Alexandria, Virginia. We have typically, since our inception in 1790, been located in the Washington, D.C. area. But again, our headquarters is now located in Alexandria, Virginia. But we do have regional offices in Detroit, Denver, Dallas, and San Jose, and one quickly coming online in December 2025 in Atlanta, Georgia. Next slide, please. With that, we're going to jump into the 4 basic types of intellectual property. As you know, we are the U.S. Patent and Trademark Office, but we like to make sure that entrepreneurs are aware of what they might be creating in an intellectual property portfolio. Jason, you want to take this slide?
Oh, I love for oh, you want me to take this slide? I can
Sure,
take this slide.
please,
Sure, yeah. I
please.
thought you were gonna throw patents to me. I was like, no, you don't
Well,
want me to talk
we
about
can do that
patents.
too.
You
We're
don't
going
want
to
that. I
test his intellectual property chops.
do not have a technical background. I'm not allowed on the patent side of the building. That's not true. I am allowed over there. All right. So as you can see on the screen, folks, intellectual property does kind of break down into these 4 major types. So Liz is going to talk about what a patent is and how that could help you as a small business. So as you can see here, really what it's doing is protecting your new invention, a new way of doing something. You can see perhaps it's maybe it's a new way of charging an electric vehicle. Maybe it's a new solar panel. Maybe it's a new pharmaceutical, right? And there's all sorts of other things that happen in the patent world that just don't get a whole lot of play, like design patents and plant patents. Most of the time we talk about utility patents. So if you think about it, folks, so think about your small business, for example. Maybe you are this garage inventor, or maybe you're in a lab, who knows, right? But you've created this new thing, right? That's going to change the world. And you want to have protection for this new technology that you've created. Well, one thing you might want to think about is when you take it out in the field to market it, what are you going to call it? How are people going to know what your new thing is? You're going to need a brand name, a slogan, a logo, something along those lines. And so there, what we're talking about is a trademark. And that's what I'm going to be talking about mostly today. And it's hard to shut me up when it comes to trademarks, but we'll do a pretty good job of that today. So you would want to know, okay, I've got my new thing. What am I going to call it? How are my customers going to know what to call it in the marketplace when they walk into a store, when they go online and they're searching to find it? That's going to be your trademark. Now, a copyright is similar, right? It's another type of intellectual property, and it protects original creative works. So if you want to think about, I don't know, the website that you create where you're going to sell your new product and tell people all about it, well, guess what? A website could be protected by copyright. Same thing with an advertising jingle that you come up with, right? Something along those lines, because it's really protecting things like songs, movies, books, that creative stuff that you put out there in the world. And a trade secret, well, it sounds kind of what it Well, it is what it sounds like, okay? It is something that you know that nobody else knows how to do. And the fact that nobody else knows how to do it, that means that it has value, right? And so, and you're taking steps to stop other people from getting that be a trade secret. So these are the 4 types. We're going to dig in a little bit deeper on all of these things, but that's kind of a nice overview, and you can kind of start to see right now how they all interact. So let me throw it back to you, so you can talk about patents, because people do not want me talking about this topic.
Happy to do so, Jason. And I'm glad we're having this conversation together because, and I'm going to hope you call it out in your presentation. I've heard sometimes that while some people are creating something protected by a patent, nearly every business, if not every business, has something protected by a trademark. So trademarks are such a valuable part of this conversation today. So let's talk about patents. What is a US patent? Well, a patent is a grant of a right from the federal government in exchange for an inventor disclosing their invention and disclosing it with such specificity that others can make and use it. As an inventor has the possession and the right to do whatever they'd like with their invention. They can keep it secret and just enjoy it themselves. They can share it with family and friends. But to really enjoy the power behind that invention, we want to incentivize inventors to disclose it in a US patent so that others can benefit from it. So that US patent grants the right to exclude others from making, using, selling, or offering for sale the claimed invention for a limited period of time. If we jump back to that language of the Constitution, which I know you only got to see very briefly, Congress has dictated that copyrights and patents are for a limited period of time, after which that material becomes part of the public domain. The patent system is what we call a quid pro quo, a this for that system. As I said, in exchange for the inventor providing their invention, knowledge of how to make and use it, we will give them the right for a limited period of time. And for utility patents, as Jason alluded to, that's 20 years from the date of filing. We allow that inventor, that property rights owner, to exclude others from using their invention, selling it, importing it without their permission, thus keeping the value, the potentially monetary value, in the rights of the inventor. So patents, like all other forms of intellectual property, are territorial. It's important that we keep that in mind. So as you look to grow and expand your business and perhaps hope to interact with organizations and customers overseas, you're going to want to think about seeking international intellectual property rights given by other foreign US intellectual property offices. So patents protect a new and useful process, machine, manufacture, composition of matter, or improvement thereof. We've issued over 11 million US patents and are rapidly approaching patent number 12 million. Perhaps it'll go to one of you who is on with us here today. And they have created the greatest technological repository of information the world has ever known. So when we say improvements thereof, 99% of US patents are improvements on existing technologies. So the patent system serves as the basis for building new and additional technologies. Jason, let me turn it over to you. I think we're on to trademarks for a little bit of a deeper dive.
All right. So, as you heard when I gave a little brief overview of the 4 things, what we're really talking about here, folks, are like things like brand names, slogans, and logos. If you want the technical legal definition, sure, go ahead and read what you can see on the screen. Okay, it's any word, phrase, symbol, or design or combination of these things that really does 2 things. It identifies the source of goods and services, and it distinguishes them from the goods and services of another party. All right, so what does that mean in terms of you and your small business? All right, what is the thing that you use for your customers to say, when I see that brand, I automatically know who that is. And in addition, I know it's not her competitor, right? So think about, for example, Nike. When you see the word Nike or see the Nike swoosh, boom, it automatically calls to mind a very specific set of goods or services. Perhaps shoes, perhaps sporting equipment, clothing, sponsorship of athletes, whatever it is, right? If you see Coca-Cola, what do you think of? Soft drinks, McDonald's, hamburgers, Ford, trucks, Apple, phones, right? So every single time you see or hear or experience that trademark, it makes you think of a specific product or service. And you can see there a service mark it's essentially a trademark. We just call it something a little bit different when it has to do with services. But seriously, folks, don't worry about the difference. You can go ahead and call it a trademark. It's no big deal. Oftentimes we just call it a mark. Okay, so think about what you have and what you are using to help your customers find you in the marketplace and distinguish you from your competitors. That is key. Okay, the connection between the trademark itself and the underlying good or service that you provide. Without that relationship, it is not a trademark. It's just a cool word or a funny slogan or a pretty picture, right? You're not really going to be able to protect that through trademark. So it's got to have that connection to goods and services. So let's take a look at what some of these can be, right? So the main ones that we think about when we think about trademarks, the traditional trademarks, are going to be things like brand names and slogans. You can see there Starbucks, Nike, Target. Right? When you see those things, boom, you automatically know, that's where I go to get my coffee or milk-based beverage, right? You see Nike, you think sporting goods. You see Target, you think, retail store services. But it doesn't just have to be a word. It could be something that is a design, or it could be a combination of those, right? So you see the Starbucks logo from, 100 yards away. You're like, yes, I'm going to get my coffee fix. You see Nike, the swoosh, you automatically know. Same thing with Target. You're driving by and you see the bullseye. And you're like, oh, yes, that's where I go to pick up, whatever it is you're buying, right? And it could be a combination of those two, right? It doesn't just have to be a word or a design. Sometimes small business owners talk about their logo, and their logo is a combination of wording and a design. Yeah, sure, absolutely. That's great. You could totally do that. Let me tell you something, folks. Here's the thing that a lot of times people don't talk about, don't think about. Trademarks are not just limited to words and designs and combinations. Pretty much anything can be a trademark so long as it indicates source. If you've ever seen pink fiberglass insulation, you were looking at a federally registered trademark. That was one of the first color trademarks to be registered by Owens Corning. And they said, hey, when people see our pink fiberglass, they think of us. And we said, yeah, okay, you're right, right? If any of you have been lucky enough to receive jewelry in a robin's egg blue box, you were looking at a federally registered trademark, even though you were probably looking at the diamond inside instead, right? But that's a registered trademark of Tiffany's. And something that we probably see every single day. You look out the window, you see a brown panel truck parked out there. Somebody hops out in their brown uniform, right? We all know that's UPS. And UPS has registered the color brown when used with their panel trucks for their parcel delivery services, right? That does not mean that UPS owns the color brown or that Tiffany's owns the color blue, right? What it means is when they use it with their very specific things, it indicates the source of their very specific products. And that's not all. There are all sorts of things. If you've ever seen the contour shape of a Coca-Cola bottle, you're looking at a federally registered trademark. So do you have to have one of these things? No, you don't, right? You don't have to have some sort of non-traditional trademark. But here's what I want you to do, folks, is I want you to think creatively about what it is that you use to help your customers identify you in the marketplace and distinguish you from your competitors. That is potentially something that you can protect through a federal trademark registration. Now, I say federal trademark registration, and the reason that I say that is because trademarks kind of exist as soon as you begin to use something to indicate the source of your goods and services. Here's the analogy. You tell me whether this works or not. Let's say you go to Target and you buy a toaster. Right? You get your toaster, and that toaster that you buy for 20 bucks or whatever, it comes with a limited warranty, right? You go, oh, this is good, for like in the next, if it blows up in the next 30 days, right? You're covered, right? But what comes along with it is like a little postcard or maybe a thing to sign up online to get that extended warranty, right? So this is how I think about it. When you start using a trademark, you're getting that, kind of low level protection. Is it protection? Yes, you can go into state court and stuff like that and try and protect yourselves. What you really want is that nationwide protection, that long-term protection. That's when you're sending something in to register your product with the company that built it so you can get that kind of extended warranty, right? So think about federal trademark registration as getting protection for your trademark across the entire United States and its territories. And there's all sorts of benefits that come along with that. If you want to know more about it, trust me, I could talk for hours on it, but I'm going to move on because we do want to talk about other bits of intellectual property. The other thing I do want to say, though, as we move out of the trademark portion of this, is like Liz was talking about how patents are territorial, trademarks are territorial too. So there's no one place that you can go register your trademark and all of a sudden have protection around planet Earth. Doesn't exist, okay? If you want protection in the US, you file in the US. You want it in Canada, you file in Canada, Mexico, and so on, right? So like your patent protection and your trademark protection and copyright protection, you are going to want to think territorially, right? So you're going to want to think, where am I going to be and where am I going to want to protect my trademark? And we can talk more about that in a little bit. So
Let me just jump in. I'm sorry.
Go ahead, Joe.
Not to help you lose your flow here, but just one thing that I think is important when we talk about all of these protections is inherent in this is that what it does is it allows people and entrepreneurs to create value. And there's some places in the world that they don't necessarily look or understand how can you go ahead and put a protection around an idea, right? But we as an American Innovation Society say we want people to go ahead and be able to capture these and then create wonderful products and services and ideas around that make our lives more convenient, make things easier, bring about greater well-being. And so I think it's really important to acknowledge that it's not just about the money side of things. It's really about being able to create a sense of ownership for innovation purposes and allow people to go ahead and be creative and explore those areas of creativity. You know, in the Constitution piece that Elizabeth showed, it said what in usable arts or creative arts or whatever the language was there, right? So it really is expansive. It's not just about money making. It's also about being able to create and to protect some of those pieces. So I didn't mean to go ahead and front run you, but we do get this question a lot when they ask me, our students, when they ask Amber and me, we talk a little bit about that. This is important, not just because you want to own it and make a lot of money, but it also spurs creativity and innovation. So.
Yes, I love that, Joe, especially if you think about some of the earlier trademarks that might have been out there. Well, if you want to talk trademarks and quote branding, right? We go all the way back to somebody branding their cattle or branding their wildlife, right? Or we think about the mark that somebody might put on the bottom of a brick in ancient Rome or on a Grecian pot, right? Right. That's really branding in many ways, and it goes back, hundreds, if not thousands of years. And so we have been innovating on branding for some time. Way back in the day, were you going to be able to protect your signature scent? No, you might have had a signature scent in ancient Rome, but that's not something you're going to be able to protect as indicating the source of your particular bricks. All right. But we've really innovated over the hundreds and thousands of years. And so that's something you can take advantage of if we think about how trademarks have changed even over the past 100 years. Like we have registered trademarks that are over 100 years old. They're either really plain or they're like really kind of in depth. That's not what we do anymore. Look at what you see on your screen. You got a stylized check mark. You got a bullseye, right? But when we see it, we know who it is. You don't need some fancy sort of thing. Apple computers went through this exact thing. Their original logo was a really complex sort of thing, like somebody sitting, I think Newton maybe sitting underneath the apple tree, right? Is that now? No. It's got a bite taken out of it, and that's it. So, and the other thing I will say though, and Joe, before we move into copyrights, I'll just say this, Joe mentioned it's not just about the money. It's not, but I tell you what, there is money, right? So there is value that is created in your trademark. Now, we don't do trademark valuations, okay? USPTO does not do them. There are companies out there that do. I've looked at various valuations over the years of various things. I'll tell you what, folks, there are brands like Apple that some folks value the brand alone in the $200 billion. I've even seen somebody who said it's worth $800 billion. And that is not the phones and the computers and whatever, it's the value of the brand alone. I mean, if that's not mind-blowing, I don't know what is, right? Because like a patent, a trademark is something that is a property. If you think about, yeah, when I'm done with my car, I'm going to sell it. Well, when you're done with your business, you can sell it, including your trademark. So let's say you wanted to sell your business that had an $800 billion valuation on your brand. Hey, not a bad payday. All
Yeah,
right,
you know,
let's
to
we're gonna.
this
Oh,
actually
go
to
ahead,
this
Liz. Yeah.
conversation that we're having, the Office of the Chief Economist at the U.S. Patent and Trademark Office has published a series of reports which reflect that IP-intensive industries, those industries backed by intellectual property, have greater wealth, they have greater jobs, greater high-paying jobs, and you know, that property right does bring value to a business. It
Sure.
makes it attractive to investors. It makes it attractive to buyers. Um, Companies having intellectual property, an intellectual property portfolio of one or more pieces, are more likely to get venture capital funding. There's numerous documentations of that. I mean, a simple example is how many of us have ever watched the show Shark Tank?
Yeah.
And
I was thinking
invariably,
of
the
that. Yep.
sharks, they
What
always
do you have
ask.
protected? Like how is what, and actually when you look at investors or you listen to some of the folks, they talk about protective moat, right? So what is that protection
Certainly.
around the business? And what you guys are talking about inherent in all of this is that protective moat at the very basic when you're starting your company, right? What does that protective moat look like so that as you continue to move forward and you're adding value, your business grows, that your mark continues to grow because you might be starting off as a very small concern and then selling sneakers out of behind the back of a van or jeans out of a truck like Calvin Klein, and then all of a sudden it grows into a large brand. And so these conversations are really important. Actually, one of the questions that we always get is how do I protect it from somebody stealing my idea? Right? How do we go ahead and protect it? So, you guys as at the patent office having a great, amazing array of resources that people can avail themselves to, and a series of presentations and webinars on a regular basis. I've subscribed to the emails, and I've been on a couple of those amazing webinars. But I don't want. Let's go ahead into the copyrights piece because I know that that's an
Certainly.
important piece as well.
But thank you for calling out some of those resources, Joe. And I hope we'll have a chance to touch on them during the presentation or at the end during the questions, because you're right. We teach classes Monday through Friday on a wide array of topics. Jason, myself, colleagues across the agency, whether it's on patents, trademarks, protecting your IP abroad. And then again, we have a number of programs and initiatives that really provide value to stakeholders. So with copyrights, which Jason has already touched on, they are administered by the U.S. Copyright Office, which is a part of the Library of Congress. However, I should say that the U.S. Patent and Trademark Office plays a role in advising and preparing copyright policy. So certainly our sister agency at the Copyright Office, we're close collaborators in working together. As Jason has said, copyrights are a legal protection for original works of authorship. And there's a wide array of things that fall into this category. Jason, do you want to jump in and talk about how copyrights, sort of like trademarks, are self authenticating and that protection exists, but can also be registered?
Yeah, that's right. This is one of the things that, people don't often know is that when you affix your idea in a tangible medium, you have a federal copyright. Done. Right. So if right now, let's say, I think, Joe, you're recording, Amber, you're recording this, right? So we're affixing this in a tangible medium. So if right now I went, USPTO is the greatest, it's the best agency in the world, right? I just sung this ridiculous little song, made up the lyrics, right? So technically, I might have a copyright in the song that I have just created because it is now affixed in this a tangible digital medium, right? Boom. You take a picture on your phone, technically you have a copyright in it. Now, look, are you going to go out and enforce that copyright? Probably not, but there are industries and things that you might do that you are going to want to be able to enforce that copyright. And that is one of the things that the Copyright Office provides because you can register your copyright with the US Copyright Office, right? So same thing as Liz noted with regard to a trademark, you're having and using your trademark. Oh, I want that extra protection. I'm going to take it to the federal agency that handles that. Same thing on the copyright side. right? Because you want to unlock additional benefits and being able to get, statutory damages when you sue somebody because they've been infringing on your copyright, things like that. Think about all the IP intensive industries that are out there, right? Like Hollywood. Okay, right? So they're going to have protection for the screenplay, for the actual motion picture itself, right? They might have it for the music and lyrics that have been created for, right? All that sort of stuff that's out there. That's the sort of thing they're going to probably register with the US Copyright Office because they want that additional protection to be able to go after folks that are infringing on their copyright.
And it's an interesting area of law because when you look back at film and photography, right? Some of the earliest cases were like determining who actually owns the copyright, right? Is it the person in there? Is in the actual photo? Is it the person taking the photo? I think actually one of the cases goes back to Oscar Wilde and a sitting that he did, one of the early cases in copyright law. I'm not an attorney. I don't play one on TV, but I just remember doing a little bit of research about this for one of the classes that I was teaching about copyright law. And then more recently, there was the whole case about the monkey that took a photo of itself, a selfie, and whether or not the monkey had a copyright, right? And there was a whole conversation that took place with animal rights people and whether or not the monkey owned this. It's just a fascinating area that continues to grow, right? Like this whole area of protection. We're looking at Open Chat GPT. I'm sure you guys are starting to get questions on that, right? And there's even some recent legal precedents that's saying, well, computer generated stuff, like who actually owns that stuff, right? So it's just it's such a dynamic area of law that just continues to change, right?
For sure.
That's right.
And an exciting area, and certainly one, you mentioned artificial intelligence. It's certainly one that our agency, as well as the U.S. Copyright Office, the administration as a whole, is really evaluating with the perspective of policy as well as implementation for our agencies.
Yeah.
So again, looking at the wide array of things that can be protected by a copyright and trying to really look at it from the business perspective. Here are some things that you may be creating that could potentially be protected by copyright. Again, you have a copyright by creating these works, but you're encouraged to also consider federally registering. Logos, product design, packaging, advertising, promotional materials, these all sound like things that may be going through your mind as you're building that business. I see we do have a question from one of our attendees. Chris, thank you for your question. And Chris has a clarifying question, and that is, does copyright cover creative expression only? Is that the same as ideas, which I just heard? So great question. Creative expression is really kind of the legal terminology that allows us to lump in all of these different things, whether it's a sculptural work, a music work, musical, creative expression, but that creative expression has to be placed, as Jason has said, in a fixed intangible medium in order for one to take advantage of securing a copyright. So when you say ideas, now if your idea is placed into a fixed intangible medium, either as a work of art or as a written document, you can secure a copyright. Now, if the idea just merely remains in your head, then no, you're not availing yourself of that copyright. It's interesting. The concept of idea often comes up in the conversation of invention and patenting. People often ask whether, in order to file for a US patent, do they have to have a working prototype? And the answer to that is no. So, in a sense, they have a mere idea. But with that said, they have to be in possession of their invention. As I mentioned earlier, you have to be able to describe your invention with such specificity that others can make and use your invention. That's what's required in your patent application. So your mere idea has to be specific enough to be put into a US patent application. I always like to use the example of, I've got a great idea, or I think I do. I'd like to build a time machine to allow me to go back in time and meet remarkable people like Abraham Lincoln and Harriet Tubman. Now, do I have an invention or do I have an idea? Let's be honest. I have a crazy idea because I don't know the first thing about building a time machine. And I'm waiting for that person who does. So, can I file a US patent application? I could, but it would be a waste of money. because I can't describe that invention in the parameters of a patent application with such specificity that others could make and use it. So interesting conversation about ideas. Ideas always circulate in the conversation about intellectual property.
I'd love to tag on one thing there. So Chris says, thank you for the response, by the way, Liz. So thanks for clarifying that. Let me give you one more example here, Chris, which hopefully also helps break down the idea between idea and creative expression. So let's say that an author or screenwriter somewhere had an idea for a book or a movie that has a kid who has special powers. And this kid with special powers, with the help of an old man and some new friends that he finds along the way, he's able to overcome the villain, right? So what did I just describe? Well, it could be almost any. It could be Star Wars, right? Could be Harry Potter, right? That's the idea, is like a kid with special powers who does all these things. But what matters is the creative expression of that idea. So that is what is being protected by copyright. It's not like I have an idea that we should be able to go back in time. That's not going to do it. Okay. But expressing that in a way that, that becomes a movie or whatever about somebody who does time travel, well, that could be different, right? You and Jules Verne come up with these things, right? So maybe that helps a little bit, Chris, and to sort of see there's a difference between having an idea and then the creative expression of that idea. One thing I'd love to point out here real quick here, while we're on this page, it really is the overlay between copyrights and trademarks. So you see there logos, product design, and packaging, right? Yeah, you can protect that through a copyright protection because it's an original artistic work. You've created this graphic design that you were using to indicate the source of your goods and services. Well, if you want to protect that creative thing, sure, you could submit that for federal copyright protection. But if you're also using it to indicate the source of your goods and services, you could submit it to our agency for trademark protection. Let me give you a concrete example. I'm sure we have all heard at this point about how Steamboat Willie, Disney's early version of Mickey Mouse, has entered the public domain. Oh, great. Steamboat Willie's in public. Does that mean that everybody in the work can go out there and do all sorts of Steamboat Willie things, right? Do you think just because that copyright is gone that all of a sudden Disney has no protection for a mouse? No, that would not be correct, right? Because Disney has other versions, copyright protected versions of like more modern versions of Mickey Mouse and stuff like that. But they also have trademark protection. So when you see those mouse ears, you automatically think amusement parks. You think TV shows, movies, merchandise, all the various things that Disney does. So you can see how something could be protected by a copyright and that protection could go away. But that doesn't mean that all of a sudden everybody out there can start doing mouse ears on their goods and services and stuff like that. Because Disney still has protection for whatever versions of Mickey Mouse they have for their specific goods and services. So you can see how they kind of overlap. And this is one of the important key points between copyrights and patents and trademarks. So copyrights and patents will go away after a while, right? Because this is the public policy. We want you as a business owner to be able to build upon the things that previous inventors and previous creatives have done. We want you to be able to take those ideas and build off of them. That's not what we want in trademarks. Trademarks is about protection for you as a brand owner, and it's about protection for consumers. So consumers aren't getting confused when they see yours and they see somebody else's, right? We don't want you to be able to create some sort of false connection or misrepresent yourself to be, or somebody to misrepresent themselves as you. Don't want that either, right? So really, we're talking about two different types of protection. Standing on the shoulders of giants over here, and then, protecting your giant brand, whatever, Jolly Green Giant brand peas and green beans or whatever it happens to be. All right. So two separate sorts of things, but there is overlap between the two.
And Jason,
Yeah.
to the point you're making, the value in a trademark is so incredible because inherently it can last forever, correct? If it's continually used in commerce, renewed with the office, with the US Patent and Trademark Office when required. So that value is everlasting as long as that company continues to be a part of our world of commerce. So amazing.
I want to go, we're going to be coming up here on time here shortly, and I want to go back to the resources that you guys have and provide, because there's one thing that's important that I learned as going through the work, and I think maybe it was even last year or the year before, that I think it's important for people to understand that they really need to get their arms around this and speak to a professional if they're really going to be doing work in this area, because there are some other considerations where you start putting stuff out there in the public domain, and really understanding before you put stuff out there what that actually means. And now I don't know, with specificity what I'm talking about, but I know that you guys are shaking your heads because you guys understand that if somebody's doing some work in this area, they want to be mindful and cognizant of the fact that once they put something out there, it can change and have significant ramifications on their ability to protect that in the future. And so the resources that you guys provide and the ability to go on some of these webinars and calls, and I've been on them, and they're great. They're amazing people come to the table who know so many different aspects of things. So anybody who's listening to this, whether it's today here or listening to the recording, go to the patent office and register for their webinars and their events, because it's important for you to understand, and you have access to amazing professional people who are very, very technical and can help help you navigate, as well as point you into other resources that can be available.
Well, and Joe, thank you for that kind call out and that cautionary tale, because you are right on point. As I like to say, sadly, sometimes by delaying in protecting your intellectual property, you're in fact precluding yourself from protecting your intellectual property. Once it's out there in the public domain, others become aware of it. We won't get into the nitty gritty of patents and grace periods, but yes, and this webinar today is a good first step. It's a good first step for people to get their feet wet in understanding the concepts of intellectual property, understanding and appreciating the role of the U.S. Patent and Trademark Office, and the fact that we are an agency of communication and collaboration. We are here to help inventors, entrepreneurs, business owners in protecting their intellectual property. And I love that you've referenced our classes, because our classes are all free. And again, they're on a wide variety of topics, and they're intended for people from all walks of life that are looking to know more and looking to engage with the U.S. Patent and Trademark Office. I'm so glad that you all have pulled up our website. Hopefully everyone on the call today and everyone who watches this at a later date has visited us at uspto.gov. But I will say our website is so rich with resources. Sometimes it's hard to find the really good stuff. So, maybe Jason and I could take a few minutes to call out some of the things and where to find them on the website, and talk about some of the resources that you've mentioned, Joe, but other things as well too that we think are worth giving a shout out to in the last few minutes that we have left.
Well, let's do this. I want to go ahead and just see if there's any other questions. And then if need be, we can go ahead and set up another time to actually go through some of the resources, because that actually might be helpful for us to do that as maybe even an independent event. Amber, I don't know if you had a question or anybody else had a question, and then we can come back to that. Elizabeth.
I do, but it's so random, and so Jason and Elizabeth, I'm sorry, I'm gonna throw this on you. I am a Kitchen Nightmares fan. And there was an episode of Kitchen Nightmares that I distinctly remember where it was a restaurant in Baltimore that trademarked the word hun, which was like a cultural movement in Baltimore. And so she actually received a lot of backlash because she trademarked a term that was, to that community, considered very public. So I wonder, I mean, what are your takes on kind of like, when is it appropriate to trademark something that you think could be really beneficial to you, but is like, it's a cultural part of a community? So I'm just curious. I'm interested in, is there a detrimental part of trademarking to certain things like that, for instance?
Sure. Well, so I have to be careful about what I say, okay? Because I'm not allowed to comment on registrability of trademarks and things like that. We can only provide general information. But I will say, there are the things you have to keep in mind is that there are certain reasons why trademarks are refused federal registration. So if something is not indicating source, it's going to be refused. And sometimes there are words or phrases that are so ingrained in the way that we speak and do things like and think about everybody versus racism or something like that. Sometimes drive safely, think green, right? There are these sorts of things that when we see them, we don't think that's a source indicator, right? But then there are other things that, a lot of people use, but could still be a source indicator. Quick example, you might recall there was a whole big thing about the Ohio State University registering the word the, or technically the, right, to indicate the source of various things. And everyone's like, oh, no. Then now they own the word the. No, they don't. They have the exclusive right to use it with regard to, I think it's like T-shirts and hats in the collegiate athletic sphere, right? Because I think Marc Jacobs also has the for stuff in the more fashion designer sphere. So common everyday words can be registered as trademarks if they are functional in the way that they are indicating source. So even something like hun, it could be something that is potentially registered as a trademark so long as it is indicating source. Your question is about, is that appropriate, right? Especially to the people who live in Baltimore. And I cannot speak on that about whether or not it is appropriate, but I can say that there are things that can be registered as trademarks so long as they are indicating source.
But I
And
think,
the
Jason,
other
you
thing I
kind
will
of
say,
answered that question by
go
saying it's really on the business owner to put some
yes,
thought into what you're trademarking and what the after effects of that will be, because it's possible to do that. Whether or not you should is not something that the government's going to tell you to do. It's something that you should, like Joe said, we do your homework. Entrepreneurs, like, think about that.
yeah.
So yeah, no,
And speaking of homework, and one thing I will say, I know we're just about out of time here, but that homework piece, oh my goodness, that is so incredibly important. And that's because one thing is you don't want to try and protect the generic name of your thing, or potentially even the descriptive name of your thing. It's going to be very difficult for you to register that as a trademark because it's not indicating source. It's saying what it is. Like, I would never be able to register the word mug as a brand name for mugs, right? Because it's not indicating source. It's saying, oh, this is a mug filled with delicious coffee, right? So the things that you want to be thinking about as a brand owner are, what are those fanciful or arbitrary or suggestive words that are out there? A completely made up word, lot of value that can be created that way. So do that sort of homework. We talk about that sort of stuff in all of our resources and in a lot of our programming on the trademark side. So if you want to learn more about that, I do have it pulled up here, uspto.gov. I can show you some stuff real quick. I know. What time do we have to get out of here, Amber? We have to get, Joe, we have to leave.
We got
you
2
count
minutes.
us out.
Yeah,
2 minutes.
Taking us out.
HHS is up next, so they're on deck.
Okay. Well,
Chomping at the bit.
I'll show you this real quick here, folks. So this is our homepage, uspto.gov. Check this out right here in the center. You got patent basics, trademark basics, lots of great information, both of those. If you're not sure if it's a copyright, a patent, a trademark, a trade secret, take our little IP identifier. And if you're an inventor or entrepreneur, we have a link right here. I'll show you that in a second. We also have a link to free services and resources that are out there. I'll just select this link real quick. You can see all of these inventor and entrepreneur resources right here. All sorts of information for you to dive in and check out. And
This
of course,
is really
we would
a
encourage
great
you.
one-stop shop for
Yeah.
sure.
Sure
Great
is.
call, Jason.
Yeah, cool.
That is
And
great.
we, of course, would encourage you to come and come to our events and things like that. If you want to see Liz Doherty, like doing her thing, then make sure you sign up for also any of the stuff that we have coming out of her region. And if you want to be bored to tears, you can sign up for trademark programming that I'm sometimes providing. So.
No, it's incredibly valuable. Well, I know we're out of time, and I hope we've brought some value today to the community. Joe and
Absolutely.
Amber, always a pleasure to be on with you. We look forward to National eWeek 2025. And again,
Absolutely.
hope that your
Well, thank you guys so
attendees
much for
reach
this,
out.
Elizabeth and Jason. Yeah, we really appreciate it. Amber, you and I are going to have an offline conversation about trademarking the word I. That's a conversation we can have offline here. I think
National, whole trademark
there's a lot we
national.
can do with that. I want to thank you both for a fantastic and snappy presentation, Jason. It's been really super informative, and I know we get all questions from these all the time. So thank you so much. We really appreciate it. Amber, you want to count us out?
I will. And I'll also drop the link for the following one that we just mentioned. It's the Administration for Children and Families Office of Community Services. So really cool opportunity to tune in. So I'll drop that link, but I'll take us away and we'll see you at the top of the hour.
Thank you guys so much for a great presentation.
Bye all.
Thank you.
Bye.
Appreciate it.